the Workers' Party, Associate Professor Jamus Lim, and Mr. Leong Mun Wai from the PSP took a different approach. You made serious allegations regarding our public officers, regarding our agencies. I do not know why you have to take this approach, especially after I had explained what happened on Monday. I had clarified the facts on Monday. Why is it necessary for Mr. Leong and for Associate Professor Lim to still want to throw our public officers under the bus? Why is that necessary, sir? Sir, I've explained earlier why MAS, when they received the capital reduction plan, needed time to assess, and this was only in mid of July. The officers needed time to go through this plan, and because they were not aware of the undertakings and the details of MCCY's exemption that was given earlier. The exemption was gazetted, but the details and the conditions and the undertakings, that was not made public. So I don't think it is fair for Mr. Leong to expect that the MAS team would automatically know what those details are when those details are not made public. It was only after we had a fuller understanding of the set of issues, after the 6th of August Parliament sitting, that the MAS team saw that there could be a connection to what MCCY was looking at. And then they surfaced this to the board, and then we shared it with MCCY. So I hope Mr. Leong and Associate Professor Lim could give our officers some credit, could understand what they were going through, and also look at it from their perspective, from their point of view. They were not trying to do something wrong, or as Professor Lim mentioned, to lead to multiple breakdowns of communications or to work in a siloed manner. That's certainly not what they were trying to do. They were trying their very best to do their work. And when they saw that there was a link, they shared the information. They surfaced it to the board, and then we shared the information with MCCY. And this is how the government then came together across different parts of the government, taking a whole government approach, coming to Parliament with this bill to seek Parliament's approval. This is the outcome of a whole of government effort. Mr. Leong asked, who should be in charge? Shouldn't the cabinet be in charge? I would like to ask Mr. Leong, who do you think made the decision to take this bill to come to Parliament? It is the cabinet that decided that we could not allow the deal in its current form to proceed, and that's why we are bringing this bill to Parliament for approval. Mr. Deputy Speaker, I would also like to address two other points that Associate Professor Lim mentioned in his remarks, in his speech earlier. First, he talked about SIRA, which is the Significant Investments Review Act. Sir, we have explained this previously. I think Mr. Satyandi mentioned it earlier in his speech, that the purpose of SIRA is to look at Singapore's national security interests. And we will look at whether an entity is a key provider of security-related functions, especially when there are few or no alternatives, and whether it is adequately covered by existing sectoral legislation. So there is a rigorous process to decide what goes into SIRA, and I hope Associate Professor Lim understands that if we are too quick to put many entities under SIRA, I think that will go against what many other members have spoken about earlier, that how then do you maintain investor confidence and have a pro-business operating environment? So we must have a good basis, a good reason before we decide that something needs to be designated under SIRA. Associate Professor Lim was also incorrect to point out that there are no controls if companies like DBS and Singtel were to sell their shares. I would urge Associate Professor Lim to check his facts. MAS would have to approve any changes in significant shareholding for banks, including DBS, and IMDA would have to approve any changes in significant shareholding for telcos like Singtel.
Let me start by stating unequivocally that I have deep respect for the hard work that our civil servants put in, often involving long hours and comparatively lower pay than they could have commanded in the private sector. But I feel that it's nevertheless imperative for me to highlight instances where the system that the civil service operates under, which is, to be clear, overseen by this government, is problematic, because our civil servants can only do the best they can within the constraints that they face from the government of the day. So, once again, to reiterate, I'm critiquing the system, not the civil servants. I do not think it's useful to bring in the civil servants as pawns to a political argument. Now, to further clarify, I did not say that there are no protections for the sale of significant assets like Singtel or DBS, but the additional protections are granted by CIRA. Accepting that we do not wish to list every possible Singapore firm under CIRA, I still have not heard a satisfactory reason as to why the designated entities are limited to only those within the military-industrial complex, whereas our total defense pillars clearly go into financial and digital elements. Let me put this another way. Could I confirm with the Minister that this government will never consider listing assets such as DBS or Singtel under CIRA?
Mr. Deputy Speaker, I would like to start by first requesting Associate Professor Jamus Lim not to put words into my mouth. I did not refer to our public officers as pawns, and I don't think he should too. We have deep respect for our public officers. We know that they work hard, they do their work well, and it wasn't so clear earlier when Associate Professor Lim was making all the criticisms about working in silos and having breakdowns of communications that he was referring to the system. Now, if his concern is about the system, I have also explained on Monday and then earlier what happened and why it was not in the ordinary course of operations for MAS when they are assessing information from a financial institution to share that with another government agency. Now, if Associate Professor Lim considers that as a failure, a systems failure, then I presume maybe he could let me know what his counter-proposal is. Is he then suggesting, and I'm not trying to put words in his mouth, I'm only asking, is he then suggesting that anytime MAS receives information, whether there is a reason or not, we should then share it with all other government agencies? I hope that's not what Professor Lim is proposing. I think that will have an impact on investor confidence, and it will affect our pro-business operating environment. So I've explained what happened with this particular case, and I've also reiterated the chronology of what happened, and I hope Associate Professor Lim can accept that account of what happened and not keep repeating unfounded allegations about the public service officers in our system facing constraints from the government of the day when it comes to sharing of information. I don't think there's any evidence, unless Associate Professor Lim can produce evidence. Otherwise, I would like him to please withdraw that rather serious allegation. With regards to CIRA, I've already explained earlier that this has to do with national security. And I also mentioned in my reply that we will also look at whether there are other acts that cover some of these entities. And if there are, then there's no need to replicate this with CIRA. So the two examples that Associate Professor Lim kept raising, DBS and Singtel, I've already explained. There are sectoral regulators. In the case of DBS, it will be MAS. In the case of Singtel, it will be IMDA, that would play the role of the gatekeeper. And if you want to acquire shares in DBS or in Singtel that goes beyond a certain percentage, you do need the regulator's approval before you're allowed to do so.
My first point is also about civil servants, something similar to what Member Jamus Lim had just said. I quote, "Today, I've not said anything about civil servants. What I've said is, I would like to acknowledge the efforts put in by MCCY and MAS to scrutinize the transaction and come out with this bill." So this is an appreciation of the work done by MCCY and MAS. But I have directed at the ministers. It is the responsibility of the cabinet minister to ensure that they are appraised of all relevant and important information and to consider them fully before making decisions and public pronouncements. I'm saying that because on August the 6th, we spent more than 1 hour clarifying during question time about this whole deal without complete information. And so we are running parallel all the time. And you can also say that it was quite a waste of time. But what happened now is that now with more information, we know that the ministers and the NTUC Central Committee, actually they do not have the information on the capital reduction. So we understand that point. But still, we are concerned about the coordination and how things are being presented before the information is complete. So that's one point. I want to respond to the minister when he said that I'm bringing in the civil servants and all that. A point that's similar to what Professor Jamus Lim has said. The second point that the minister has said is about my characterizing the exercise as asset stripping. In finance, nobody with some knowledge about finance would disagree with me. It's a fact. It has nothing to do with the intent. You can intend, your intentions can be good, but the plan that you put up is actually not so good. You can even say detrimental. That's why government now is coming back after all more work and said, oh, this plan cannot go through. Right? The plan is not a good plan from the point of view sort of continuing with the social mission. And I got one more point to raise afterwards is that it is also not a plan that provides enough protection to policyholders. I myself being a policyholder. So it is not fair for the minister to say that I'm trying to characterize the deal in bad light. I'm just stating the fact. Anyone with basic financial knowledge wouldn't disagree with me. This is an asset stripping exercise.
Mr. Deputy Speaker, I think, I was quite dismayed to hear Mr. Leong describe the 6th of August discussion in Parliament as, in his words, a waste of time. I think it provided the opportunity for members to ask questions and for MCCY and MAS to clarify what is the status of the situation at that time, and then to hear the concerns of the members. I think it is not correct, and I hope Mr. Leong could withdraw that comment too, to describe that process as a waste of time. The point about whether information should be made known during a discussion, I had clarified repeatedly that when we came to Parliament on the 6th of August, both MOS Alvin Tan and myself made it clear that there was no regulatory approval given to the deal. It is something that is still being evaluated, considered, and therefore, in response to Mr. Leong's point about before we make any decision or pronouncement, we should have the full set of information. Indeed, that's why after the 6th of August sitting, when MCCY received the information from MAS, the agencies then got together, the ministers then got together and discussed, and eventually Cabinet made a decision to bring this bill to Parliament. This is the decision that we are seeking approval from Parliament. So I don't think there's any departure from what Mr. Leong described as what he expects the government to do. But on the 6th of August, there were PQs filed. Unless Mr. Leong is suggesting that we don't answer PQs, if not, at that point in time, because the deal is still being considered, no approval was given yet, I think it was only correct that we give information based on, or give replies based on information that we have at that point in time. But because there was no regulatory approval given, there was no decision or pronouncement by the government. The second point that Mr. Leong raised, Mr. Deputy Speaker, I find it quite odd that Mr. Leong on one hand would say he's not trying to characterize it negatively, and on the other hand, he's made it quite clear that this is a bad deal. We have explained why the capital reduction plan on its own would not be something that's uncommon. An entity, whether Income or another insurer, another financial institution, to do capital optimization, I think Minister Edwin Tong explained this, I explained this as well, and Mr. Leong, I'm sure, understands. Financial optimization is something that entities, companies do regularly. So this by itself is not wrong. So when MAS was looking at this initially, they were looking at it from a prudential point of view to see if you do this, would Income still have the necessary capital to meet its capital adequacy ratio? From a prudential point of view, is this something that we would be prepared to consider? But as I mentioned earlier in my closing speech, there was no application by Allianz on the capital reduction. They only submitted a prelim business plan in mid-July. So I would like to suggest that perhaps it's not very useful and productive for us to argue about different adjectives being used, but I think, as Ms. Hazel-Paul said earlier, we let the public decide which phrase was used by Mr. Leong and which phrase was used by me and to describe this exercise. And I think Hansard will reflect that Mr. Leong did indeed say it's an asset stripping exercise.